This speech is dedicated to the memory of Enos J. White-Eye, and you'll hear about Enos during the course of my remarks. Before answering the question, what does reconciliation mean for me as a judge? I want to cover 4 topics this evening that, in my view, will help answer that question. These topics are: 1, the development of our Indigenous Persons Court in Brantford; 2, my most important decision as a judge; 3, moving forward with our vision for the Indigenous Persons Court in Brantford; and 4, a final story of the resiliency of the human spirit. In speaking about the development of our Indigenous Persons Court in Brantford, I'd like to start by giving you a little background of who I am. You know, create a little street cred, if you will. So I am the great-great-great-grandson of Chief Joseph Brant, for which I'm extremely proud, as is my sister Erica, sitting in the second row. And you history buffs will know that Captain Brant and his Six Nations warriors supported the British during the American Revolutionary War. You also know that, unfortunately, the British lost, and the Six Nations were therefore, in large measure, persona non grata in Upper New York State. But for their support of the British monarchy granted Brant and the Six Nations a tract of land on 6 miles on either side of the Grand River from its source to its mouth. Well, fast forward with me to 1982, when I was called to the bar in the province of Ontario and started practicing law in this very city. The Brantford Provincial Court was the catchment court for offenders from Six Nations, and I would routinely see folks from Six Nations head down, resigned to their fate of getting jail and more jail, and often having only uttered one word: guilty. Little time, you see, was spent getting to know who these people were. By the late 1990s, our top court, the Supreme Court of Canada, began to weigh in on the issue of Canada's over-incarceration of Indigenous offenders. It started with that court's decision in Regina and Gladue. Jamie Gladue was a Cree woman from Alberta. By 1995, she was sick and tired of her partner calling her fat and ugly and not being as good as the other women in his life. After a night of drinking, Jamie Gladue's partner left to pursue Miss Gladue's sister. Jamie promptly followed him and stabbed him through the heart with a butcher knife. She eventually pled guilty to manslaughter and was sentenced to 3 years in penitentiary by the trial judge. The case eventually found its way to the Supreme Court of Canada, and in 1999, the court released its decision. The court took the opportunity to deal with Section 718.2e of the Criminal Code, and more to the point, the disproportionate incarceration of Aboriginal offenders. On that issue, here were some of the findings the court made. 1, the Manitoba Justice Inquiry found that Aboriginal persons made up only 12% of the population of Manitoba, but comprised over 50% of its prison population. 2, nationally, Aboriginal persons represented 2% of Canada's population, but represented fully 10.5% of persons in federal penitentiaries. 3, in Saskatchewan, Aboriginal people constituted between 6 and 7% of the population, yet by 1995 represented 72% of that province's prison population. The Saskatchewan experience led one commentator to write, "Put another way, this means that in Saskatchewan, prison has become for young Native men the promise of a just society which high school and college represent for the rest of us. Placed in a historical context, the prison has become, for many young Native people, the contemporary equivalent of what the Indian residential school represented for their parents." And so there it was, that term, Indian residential schools. In the late 19th century, early 20th century, the Canadian government built some 160 residential schools across Canada. This indeed marked a dark period of Canadian history as it related to this country's treatment of Indigenous people. The last residential school closed in 1970. It prompted then Canadian Prime Minister Stephen Harper to rise in her House of Commons on July 11, 2008, and offer in part the following. Quote, two primary objectives of the residential school systems were to remove and isolate children from the influence of their homes, families, traditions, and cultures, and to assimilate them into the dominant culture. These objectives were based on the assumption that Aboriginal cultures and spiritual beliefs were inferior and unequal. Indeed, some sought, as it was infamously said, to, quote, kill the Indian in the child, close quote. Today, we recognize this policy of assimilation was wrong, has caused great harm, and has no place in our country. That the consequences of the Indian residential schools policy were profoundly negative, and that this policy has had a lasting and damaging impact on Aboriginal culture, heritage, and language is no mistake. The Prime Minister went on to say, "The legacy of Indian residential schools has contributed to social problems that continue to exist in many communities today." I can attest to this last statement. As Dave indicated, I was appointed as a judge in 1996. I see the legacy of residential schools far too frequently in my court. Cases like Terry's case are not unusual. Terry, not his real name, is a registered member of the Salt River First Nations. Terry's mother attended residential school at Aklavak in the Northwest Territories, at the Aklavak Catholic Indian Residential School. Terry's aunt believes Terry's mother was sexually abused at that residential school. For Terry, the impact of residential school on his mother was simple. She never told me she loved me, not till late in my teenage years. She had problems with affection. Terry did not attend residential school, but he clearly was impacted by his mother and his stepfather's attendance there. Terry's mother suffered from alcohol and gambling addictions. His stepfather, who was described as, quote, raised in the residential school, close quote, inflicted emotional and physical abuse on Terry. At the age of 4, Terry and his sister were taken by social services and placed in a non-native foster home. According to Terry, quote, basically I was institutionalized from when I was 4 years old. I've been traumatized all my life, close quote. Terry was returned to his mother and stepfather at the age of 6. According to Terry's sister, Terry wasn't treated very well by his stepfather. She said her stepfather would physically abuse Terry, whether he, the stepfather, was drunk or sober. She said Terry received the worst when the stepfather was actually sober. She described one incident when the stepfather poured boiling water over Terry's head. Sometimes Terry's mother would try and protect him, but she was addicted to alcohol and gambling, and so would often be away drinking and gambling. As Terry says, they were part-time parents. I felt I had no childhood. By 10, Terry started drinking. By 13, Terry had been sexually abused. Terry never talked about this abuse. Between the ages of 29 and 35, Terry was homeless. He would, quote, drink all the time, every day, close quote. His criminal record started in 1990 and now has some 58 entries. His last conviction was for manslaughter as a result of a drunken brawl for which he received a penitentiary sentence for 4 years. While serving his sentence at Collins Bay Penitentiary, Terry took up letter writing with a girl by the name of Barbara. He eventually was released and came to Brantford to reside with Barbara. Barbara described Terry as a hard worker who had held down a roofing job with the same employer for some time. Barbara has 4 children. One of them just gave birth to Barbara's first granddaughter. While pregnant, this daughter was using drugs, and Terry was upset over this. And once again, Terry's temper got the best of him, and he ended up threatening the daughter and breaking the door to her residence. So Terry got charged with threatening his girlfriend's daughter and causing mischief by damaging property. In 1982, and probably right up to January of 2014, my experience, first as a lawyer and then as a judge, would surely be to say that someone with 58 prior convictions is in all likelihood going to go to jail. But things had changed for me with the approach I was taking to Native offenders. Yes, I'd read Regina and Gladue, which made it clear Canadian courts were over-incarcerating Native offenders. I read the Supreme Court of Canada's decision in Regina and Ipili, released in 2012, which told judges, in essence, you still haven't changed your ways. You're still over-incarcerating a disproportionate number of Native offenders. But for me, it didn't hit home until one day in criminal court when I was dealing with a number of guilty pleas. 2 accused were charged with the same offense, disqualified driving. Defense counsel for the one accused, a Native offender, was making an impassioned plea to spare her client from jail based on Gladue principles. Yet my usual sentence was a custodial disposition of 30 days. The other offender, charged with disqualified driving, was a non-Native offender. Was I to treat the 2 accused differently in the space of 5 minutes in the same courtroom? It was at that point that I concluded I needed to set up a separate court for Indigenous offenders if I was going to do justice to the Supreme Court of Canada's dictates in Gladue and Ipili. The process for establishing the Indigenous Persons Court in Brantford first saw me consult with the Six Nations community about setting up such a court. For too long, Canada's legacy is one of forcing ideas upon First Nations communities. But with the eventual approval of Six Nations Band Council and a dialogue with the hereditary chiefs, I then set up a community group to act as a sounding board at monthly meetings. This group offers invaluable feedback from the community. After this initial legwork, I finally said it was time to start the court, and in January 2014, the Indigenous Persons Court in Brantford opened. The Indigenous Persons Court has the appearance of a regular criminal court. However, the court requires that the Indigenous offender intends to enter a guilty plea. We will accept all pleas save and accept domestic violence charges. However, even here, we're thinking of changing that process in the future to include cases involving domestic violence. We also deal with Native youth under the Youth Criminal Justice Act. Like any other criminal court, the accused is arraigned and enters his or her guilty plea, and the facts are read in, and the guilty finding is made. The issue of sentencing is then discussed. If the Crown is seeking a jail sentence greater than 4 months, a Gladue report is prepared. This is a report prepared by specially trained writers from Aboriginal Legal Services in Toronto. These reports deal in depth with the accused history, with special consideration given to the impact, if any, of residential school fallout on the accused and his family. Once we have the report, we then conduct an adult conference or circle. The legislative authority for this is contained in section 726.1 of our criminal code, which reads as follows. In determining the sentence, a court shall consider any relevant information placed before it, including any representations or submissions made by or on behalf of the prosecutor or the offender. At this adult conference, I'll begin by indicating in open court that we are dealing with a particular accused and suggest the matters to be discussed are of a private nature. I don't order the courtroom cleared, but invariably people respect the process and leave the court, save and except for the offender and his family support. The court recording equipment, however, remains on, so it remains a court of record. We then literally move chairs in a circle, and I come down from the dais and join the accused, members of his family, support people, defense counsel, Crown, Native court workers, and now, new to our court, Indigenous knowledge holders. One of them is present tonight, Jan Longboat. Jan. And remember Terry. Terry came before our Indigenous Persons Court in Brantford. He pled guilty and a Gladue report was ordered that basically set out the background I've alluded to. After receiving the Gladue report, we conducted an adult conference, sat in a circle, and talked, and talked, and talked. We talked about Terry's life and his problems. Then this 43-year-old hardened criminal with 58 prior convictions broke down. He talked about the abuse that had caused so much pent-up anger over the years. As part of his non-custodial sentence, we sent Terry to a healing lodge for 6 weeks. We brought him back to court after the program, and I looked out into the body of the court, and I looked again, and here is this man smiling with his 1,000-pound weight off his shoulders. It was Terry. Terry now continues to be on probation. Now over a year has passed, and Terry has not reoffended. One of the biggest comments offered by way of feedback from defense counsel or even the accused themselves in our Indigenous Persons Court is the opportunity to be heard in that court. It just seems to make a lot of sense to give the accused the opportunity to tell the judge his or her story rather than simply receiving one word, guilty, from the mouth of the offender. But our court is not all about successes. Maynard had been charged with a series of offenses in Cayuga and Brantford. We dealt with all the charges in Brantford. We'd conducted a circle and arrived at a non-custodial disposition, weighed heavily on counseling and treatment for Maynard's alcoholism. Within 3 months of his sentence, Maynard was found lying drunk in front of a liquor store in Caledonia. I sentenced him on the remaining charges and new charges to 13 months custody to be served at the Ontario Correctional Institute. Yet, despite this setback, I still believe in the fundamental good we're doing in Indigenous Persons Court in Brantford by giving offenders a voice and a say in their future.